Hello, it's Philip Taylor speaking from Richmond Green Gems in London, and today I'm looking at a book from Edward Elgar Limited. They're an independent publisher based in Cheltenham in Gloucestershire. They produce very good books and very important books for us, and this particular one is called Operating Law in a Global Context. It's comparing, combining and prioritising. It's been written by Jean-Sylvestre Berge and Genevieve Helleringer. I hope I pronounced the names correctly. The book's available as a printed version book, which we've got here, and as an ebook. And it's also available at Elgaronline via the electronic system. I don't favour that myself because it's more difficult to actually use the book, although it's easier to read, perhaps if you're on a train and so forth. Although I do like to cross-refer to different pages when I'm looking at a book. It's not as easy to do that with the electronic version. Now, Elizabeth and I have discussed this book, and we've only done a short review of this particular book. We've given it the title, A Book for Our Times, The Importance of Globalisation. And we'll talk about the book in a minute. Let's have a look at it first of all. It's a hardback. There we go, there's the book there. And then there's the spine. And then there's the back of it. It's both people are professors, and they come to us with a very high pedigree, as to be expected from Edward Elgar, who provide us with very good quality publications. The index, it's only 200 odd pages long, the book. The index has page numbering, so you can find things quite quickly. It's quite a detailed index, and it explains, the references are to when it gives a range of pages. It's a discussion about a particular subject, so it's not too specific, but it is the page numbering rather than paragraph numbering. Then of course there's a very substantial bibliography, what they call a selected bibliography, and then there are some there are tables in fact at the back. But let's go to the front of the book. That's the main front page of the book there, and then after that you've got the blurb concerning how to get online and have a look at it online. Then you've got the structure. You see it's split into three parts. Part one is comparing national, international and European law. Part two, combining national, international and European law. And part three, the prioritization of national, international and European law. It's a total of 9 chapters. And there's a conclusion in the 9th chapter. Then there's an analytical table of situations and examples used. The preface is relatively short and to the point. It says lawyers have to adapt their reasoning to the increasingly global nature of the situations with which they deal. Often rules formulated in a national, international, European environment have all to be jointly applied to a given case. That's been one of the problems really by people, certainly some of the people who don't like Britain's membership of the European Union. They've seen that there's too much of a taking away, if you like, of sovereignty. And of course the book here is trying to look at some of the difficulties facing lawyers, which the preface very nicely sets out. There's a useful abbreviations section, and then you've also got, which is helpful because it's easy to forget what these abbreviations mean. Then you've got the tables of cases sections split into individual member state countries, UK at the back of course, table of legislation, which is always helpful, and then you go into the book itself, the introduction. And it gives some fairly interesting examples. I think it's very well written. It's not difficult to read either. Some of these books are, putting it bluntly, actually, because they're at a very high level. But this book I found quite easy to read. There's footnoting, you can see at the bottom. There are some boxed sections of examples, if you like. You can use whatever term you want, samples, case histories, whatever they are, situations they call them. And basically it's looking at some of the problems well, when we are operating law in what they call this global context. I think it's a book for our times. That's really what my own feeling is. As I said, I haven't written a long review here because what we're talking about is that the independent publishers, that's Edward Elgar, have maintained what I think is a really tremendous scholastic record with this book. and they've given us a complex and detailed examination of what the two authors, that's Berge and Helleringer, have achieved with what is a fascinating book, produced just at the right time as we reach a global crossroads, if I can dare to use such a descriptive image, with where we are at the moment, because the decision by Britain to leave Europe, I think, is a really major change and an international one of which will have reverberations for a long time. It's the biggest single, I wouldn't call crisis, but it's the biggest single main decision which Britain has faced since World War II. And I'm not being melodramatic about it at all. It could have very serious long-term implications, not for people of my age, but for people who are just beginning their careers today, where they're going to be looking at frankly, I think, at a very different world in terms of our trade agreements, our commercial agreements, and all the other things that we actually do in our relationships with people in other parts of the world. Hence the argument about how the law and legal systems and legal rights and remedies will be ascertained and enforced in the future. Now, what we've got here is lawyers, of course, and this is really taken from the basis of the book. Lawyers have got to adapt their reasoning to what they describe as an increasingly global nature of the situations they deal with, and often rules formulated in both national, international, European environments must all be jointly applied to a given case. That is the basis of the statement of the mission, if you like, for the authors, because that's really where we are at the moment. And so what they're trying to do with the book is to seek to make explicit the analysis that the lawyer engages in every time he or she is confronted by the operation of several laws in different contexts, and basically trying to find which one is the best one for them. Now, the reasoning is organised according to the basic three-step approach which the authors have adopted, consisting of a comparison in part 1, a combination in part 2, and finally the prioritisation, that means the ordering, if you like, in part 3, the priorities that are attached, of the methods and solutions of national, international and European law to be used to solve a specific case. And I think that's very helpful. They convey, the two authors, a most useful detail of how the law is operated through a wide range of concrete examples, cutting across domains including criminal law, contract law, fundamental rights, the internal market, international trade and procedure. And of course things are in a state of flux at the moment, because there will be changes from March 2019 when Britain leaves Europe. Now, the book also emphasises the need of a global lawyer who must reach conclusions in what they describe here as a pluralistic context, and illustrations are taken from the domestic case law of the United Kingdom, Germany, Belgium, Italy, Spain, France and the United States. And they're used to demonstrate how lawyers can combine different contexts to improve their legal reasoning. Now, let me conclude in, as I say, a relatively short review this time round, that we feel that this particular book from Elgar, Operating Law in a Global Context, and that's comparing, combining and prioritising, those are the important words that the subheading that is used. This book will appeal to lawyers in all the jurisdictions that are referred to, and I think much wider, because it's got a worldwide appeal, hence the global context, of course. And therefore, I think it will also be very helpful to students training to practice in a global environment at a time of unprecedented change across the legal globe, and the advent, of course, of artificial intelligence, which is coming in at the moment. And I, for one, like many, have very little idea of exactly how that is going to work out, because it could mean a lot of very big changes. It could take away a lot of work that we currently do ourselves as human beings, which are probably going to be unnecessary in the future. Anyway, the publication date of the book is 2017. I'm recording this in the summer. Let's have a quick look again. There's the front of the book, there's the spine, and then there's the back. Now if I open it up, so let's say we've got here part 3, the prioritisation of national, international and European law. This is really I think, we're looking at comparing, combining and prioritising. I think the prioritising is probably the important thing, because they say, you also say the first 2 steps, the comparison and combination, offer a large toolbox allowing lawyers to apply national, international and European law in a global context. The 3rd step attempts to fight the effects of this, what is called this pluralism, which may create disruption by favouring the application of one law over another. And that is where, I think, where the problem has been all the way through. And that is that it's rather like what happens when you have to go in front of a judge because you can't negotiate something with the other side. The judge will impose the judgment on both parties and neither of them will like it. But he or she's got to make that decision. And you've got something similar here, because you're saying, look, does the law of the CJEU, is that more favourable than a decision of the United Kingdom Supreme Court, for instance? And that's an interesting argument, I'm sure, which we will hear more about in future, because we still don't really know whether in fact the Supreme Court in the United Kingdom will be the highest court or not. I suspect it will be, but remember the basis of what was the old Court of Justice of the European Union, the CJEU as it now is, or the European Court of Justice as it was then called. The aim initially was it was only going to have effectively a persuasive effect, not a rigid effect on our own member state national laws here in the United Kingdom. All of that's changed, and that is why I think some people can understand why Brexit's happened. There are lots of other reasons, of course. However, this book, I think, does. It puts it in a global context, and it's the shape of things to come with artificial intelligence. Thank you anyway to all concerned, and to Elgar for an excellent book. Bye-bye.